I normally would love to do something interactive. I don't like to talk at people for a prolonged period of time. It's sort of one of my biggest sort of pet peeves in the entire world is when people talk at me. And so I try not to talk at people. Unfortunately, this is a format where I'm going to have to do a little bit of talking at folks, but I'll keep it brief. So hopefully, other voices can jump in and we can have more of an interactive conversation. So I think that the story of Morningside, which is a case you're all familiar with, it has to do with foreclosures of overassessed homes in Wayne County, but specifically in Detroit, really goes back beyond when we filed the case in 2016, and also goes beyond Wayne County and even beyond Michigan. It's really the story of a larger war against what's known as disparate impact, which, as you all know, is how to prove claims where there isn't the narrow, rigid proof of intentional discrimination that the Supreme Court has required under Arlington Heights. I always say that one of the biggest shocks for me when I started law school is what the common sense understanding of what discrimination is and means doesn't fit the legal definition of what discrimination is and means. So there's a whole group of things that we understand from a common sense perspective that would be discriminatory and motivated by animus, but don't meet the rigid standard of intentional discrimination. And I think we've seen some of that during the last 4 years with this presidential administration, where the president, in a variety of different contexts, whether we're talking about the Muslim ban or statements against immigrants from Mexico, has made a lot of derogatory statements, but courts have really hesitated to find that it met the definition of intentional discrimination. And so we're lucky in the context of, zooming back into Detroit, we're lucky in the context of the Fair Housing Act that we have this protection against disparate impact, or even if you don't have the rigid, narrow proof of intentional discrimination, if you have a policy or practice that unjustly harms one group more than another and a less discriminatory alternative is available, you can seek relief for that. And this, both in Magner, in Mount Holly, and then in Inclusive Communities projects, three Supreme Court cases, individuals tried to limit the scope of relief under the Fair Housing Act. And so when relief was available, when the Supreme Court held in 2015 that individuals could sue under the Fair Housing Act for disparate impact, it was a huge victory, and it became important to us to build upon that victory and seek relief for victims of discrimination like those in Detroit, who may not have this rigid proof of intentional discrimination, but do have found policies or practices that harm one group more than another, and legitimate alternatives are available, which would have less of a discriminatory impact. And so we began working with the ACLU of Michigan in 2015 when they reached out to us, and we had read reports and received reports about this as well, that there had been a failure to reassess homes after the Great Recession in 2007, 2008, and 2009. And what this failure to reassess homes had led to was a situation where homes in predominantly African-American neighborhoods in Detroit were anywhere between 10 and 15 times more likely to be overassessed and be foreclosed upon as a result of those overassessments. So we filed a lawsuit in 2016 alleging that specific process of foreclosing on homes that had been overassessed violated the Fair Housing Act because of the disparate impact it had on homeowners in African-American communities. In addition to the Fair Housing Act claim, we also had a claim under the Procedural Due Process Clause, and this is, you'll see in a second, it's a story about how it's important to bring all of the claims you have because you never know what's going to happen in a lawsuit. We also brought a claim that the separate but related process called the poverty exemption process, which will be relevant to some of what my colleagues will talk about today, wasn't a working process for a variety of different reasons. This is a process that's required by state law, under which municipalities have to exempt individuals from property taxes if their income falls below a certain amount. And in addition to sort of the foreclosure of overassessed homes, what was happening was that this process was unduly cumbersome. Individuals had to submit report cards. Individuals had to file an application to get the poverty exemption. They had to go in person to get the application for the application. And oftentimes individuals wouldn't receive the second application, so the application after they filled out the first application, until after the deadline for the second application had actually already passed. So we filed a lawsuit seeking to fix the poverty exemption process, as well as seeking to stop the foreclosure of overassessed homes. I see the text, oh my God, how many applications for applications? Yes, it really is insane. And I'll take a segue to say that, you know, I think the city's response to our complaints was really, it was blatant and it was discriminatory. I think, you know, some of the comments from the city's lawyer in response to what we said is, you know, quote, these are not my words, these are his, the city attorney's, you know, instead of paying their property taxes, they, being the individuals who are eligible for the poverty exemption, our plaintiffs, are driving around in red Cadillacs. And so there were a lot of sort of discriminatory statements being made by the city. They were absolutely unrepentant about their process not working. So we filed a lawsuit with 2 claims, and we sought relief to fix the poverty exemption process, but we also sought relief to stop the foreclosure of overassessed homes. Now, what was tricky about this case is that it was the city who was doing the assessment, and it was the county who was doing the foreclosures. So you had to sort of decide who you wanted to sue. What was also tricky about the case is that there's something that my colleagues will talk about called the Tax Injunction Act, which essentially provides that if you're suing in federal court and your lawsuit would require the prevention of collection of taxes, your lawsuit is barred from federal court. So that was one hurdle to the Fair Housing Act claim. Another hurdle was there's also state law which provides that if a state court, so we've talked about the problems in federal court, but if a state court would have to essentially deem whether or not an assessment was proper, get into the minutia from the state's perspective of whether or not an assessment was done properly, that's the type of thing that a state court was not properly in the position to do, and that's the type of thing that should have gone to a state administrative body in charge of that as well. So we were sort of damned if you do, damned if you don't. We had problems if we go into federal court, but we also had problems if we go into state court. So we tried to sort of thread the needle. So what we did is we said, look, you know, ultimately the relief we want is to stopping the foreclosure of homes. There are arguments as to why the TIA, the Tax Injunction Act, may not apply, but we don't know whether or not those arguments are good ones. Maybe what we should do is thread the needle and go to state court. It was a judgment call, and argue that the city has already admitted that homes are overassessed. There's no question that homes were overassessed. It had been repeatedly admitted by city officials. So, you know, we don't need to get into the minutia of whether or not a particular home was properly assessed and how much it should have been properly assessed. We just need to prove that this was a home that had been overassessed and it was being foreclosed upon. That's how we tried to thread the needle. It's sort of a framing question. I think this is something you'll think about a lot the more you practice, is sort of what's the right way to frame the actual claim, or in this context, frame the policy or practice such that you're avoiding the relevant doctrines which may kick you out of court. So unfortunately, that wasn't successful. The state court found that this was something that would require the assessment of whether or not a home had been properly assessed. the Fair Housing Act claim. And so it kicked our Fair Housing Act claim out of court and said, look, you should have filed with the state administrative body. But it allowed our procedural due process claim regarding the poverty exemption process to go forward. And as we litigated the claim forward, we were able to snatch victory from the jaws of defeat by getting a settlement before class certification on the poverty exemption claim, which allowed us to get some relief for individuals that was actually broader than the poverty exemption process. It allowed a significant amount of money to be placed in a fund in which individuals who were being foreclosed upon could apply to have their homes saved from the foreclosure process. When the city, as well as other individuals, contributed significant amounts of monies to that fund, and we were able to fix the poverty exemption process. So, this is a story about disparate impact. This is a story about bringing all the claims you can possibly bring, because you never know what will happen. This is a story about, even if you lose on what you thought was your bedrock claim in the case, you need to push forward on the claim you have, and you may be able to get a settlement that sort of, to some extent, saves the day in the end. What we didn't seek in the case was damages for individuals who had already lost their homes, people who'd already not only have been foreclosed upon, but their homes had been auctioned. And I think that is a good segue point to Rami and his larger team about the work that they're doing right now.
Thanks, Ajmel. Well, it's nice to speak with everybody. And my name is Rami Fakhouri. My colleagues Betsy, Sam, and I are private litigators at a commercial litigation boutique in Chicago. And as you know, you've read some of our briefing, we're litigating a case that is in some ways a follow-on on different issues, but a different type of litigation that is trying to avoid some of the issues that Ajmel just described that they encountered in the Morningside litigation, and pursue some additional theories, including a monetary damages theory. Essentially what our case is about, and I'll give a very quick preview because I would like Betsy and Sam to speak a little bit more about our overall sort of strategic thinking about how to frame these claims, and also just about the nuts and bolts of how we thought through drafting the complaint, crafting it in a way to avoid some of those pitfalls, to anticipate issues that would come up in a motion to dismiss. And then when we got that motion, which we knew was coming, how do we respond to that in a way that puts our best foot forward, focuses on the key arguments, sort of reorients everything in a way that is most favorable to us. And so I want to give you guys our perspective on that as much as possible. But just to briefly explain, as Ajmel said, Morningside ran into trouble because the court felt that the claim was essentially directly requiring the court system to determine whether there were overassessments made. And the claims that we are bringing here try to get around that by not focusing so much on the overassessments, but rather focusing on a problem of notice to taxpayers. And that's somewhat similar to what Ajmel was describing with the poverty tax exemption portion of the Morningside case, where they were really focused on this process for obtaining the poverty tax exemption, that it was too onerous, that there were so many requirements to make it effectively inaccessible for many people in the community. The argument that we've crafted for our lawsuit, broadly stated, is that at certain times, and particularly in 2017, 3 years ago, Michigan provided inadequate late notice of tax assessments that came so late that it was essentially impossible for taxpayers to appeal those assessments. And so we're not directly attacking the overassessments, but similar to in Morningside, that fact is context for this notice violation, and essentially informs the damages of our clients because they were unable to appeal these tax assessments, and as a result they were stuck with these unconstitutional assessments. And so in addition to trying to seek injunctive relief, essentially to require the city and the state and the county each to contribute to reforming this process, our claim does seek damages to try to rectify that. But I'd like to hand it off to Sam so he can talk a little bit about the process of formulating those claims. One thing I should note is that unlike Morningside, this litigation is still ongoing right now. So you're hearing about something that is in action, that is in litigation with counsel. And of course, while we're not going to be sharing any client confidences today, since it's ongoing, I would just ask everyone to please keep this conversation within the group. But Sam, you can take it away talking about the initial work that we did. And I should say one more time that Sam and Betsy have done just a spectacular job leading this case. And so you're hearing directly from the people who have worked very hard on getting us where we are.
Thanks, Rami. Hope everyone can hear me. Just chat me if you can't. As Rami said, Betsy and I and Rami and the team at the law firm have been able to work on this case. And it's also nice to have this opportunity to get to speak to you because, you know, I'm not that far removed from where you are in this class. I graduated law school 3 years ago, and the great thing about a case like this is, you know, me as a fairly new associate has had a lot of opportunity to get involved in a case that I've come to care a great deal about and learn how to make some of these strategic calls. And I look forward to your questions on, you know, if you would have done things differently or how we assess things. But I do want to go through some of the nuts and bolts of how we came to the complaint that we ended up filing. And, you know, the background of how this case came to us is that Professor Atuahene got in touch with Rami about basically this follow-on litigation and the results of a Freedom of Information Act request that that assessed, you know, when did the city send these notices of property tax assessment in various years, and comparing when they sent those assessments to the deadlines that Detroit and Michigan law set for the appeal deadline to appeal an assessment. So we had a sense that, you know, the city was sending at least some of these notices late, and that amounted to a basic procedural due process claim. So when we were looking at these facts, we had a couple of goals in mind in framing our complaint. And the first and most basic one in filing the lawsuit is alleging the elements of a claim, which is easy to lose sight of if you get caught up in the minutia of other issues, but you want to make sure that all of the puzzle pieces fit together so that your complaint alleges fully a violation of the law and is based on facts that you've researched and have a good faith basis for alleging, and that can survive a motion to dismiss. So on the factual side of that equation, we knew that our lawsuit was going to involve the basic story of these late tax notices. And we also knew, as Ajmel was discussing in the Morningside litigation, that these tax notices were part of a broader context of a history of overassessment and foreclosure and delinquency in Detroit. So we wanted to fit all of those pieces together. On the legal side, as you read in the complaint, you need to figure out how the basic facts that you have in front of you fit into a violation of the law and fit all of the elements of each of those claims. So for us, that ended up being both procedural due process and, to bring Wayne County into the equation, a violation of unjust enrichment under state tax or state law. But to understand all of these as well, we also had to really dig into the details of Michigan and Detroit property tax assessment law and appeals of property tax assessments, and understand how the way the city handled that structure amounted to a violation of due process. So we fit all these pieces together. Beyond alleging the basic elements of a claim, the big goal that we had with this complaint, I think, was framing a narrative, that understanding that a complaint is really your first opportunity to tell your client's story and the broader story you want to tell. And there are multiple audiences for this document. It's certainly the defendants who you're suing. It's certainly the court who will be assessing this complaint on a motion to dismiss, if you can anticipate one. And for our case, we also were making a public statement that fell into the broader work of Professor Atuahene, the Coalition for Property Tax Justice in Detroit, and fit into this larger narrative. And a complaint gives you a really unobstructed opportunity to frame the narrative. And so we really wanted to ask ourselves, what is this case about and why is it important? We certainly wanted to make squarely the case about the government's massive denial of due process, which through our research, we realized that, and with the FOIA results, that basically every residential property tax notice in 2017 was sent just days before the stated deadline to appeal, and giving essentially no person any time to appeal their assessment. And as I mentioned earlier, we wanted to put this into the broader context of the foreclosure and overassessment crises. And these issues also have historical aspects and racial justice aspects that, in discussing with Professor Atuahene and others who were reading our drafts, we wanted to make sure to add those elements in, even though they weren't the bare bones essentials of making out a claim. And finally, we wanted to tell the details of the individual plaintiff stories. It brought it down to a human scale and allowed us to talk about not only how our individual plaintiffs were injured and should properly be in court, but also what did these, how do these larger systemic issues break down into an individual person's story and impact that individual person. So in all of this, it was really essential to just get our facts straight and make sure that we had everything right. Not only to avoid being caught flat-footed when we filed this with the press and things like that, but lawyers have an ethical and legal obligation to file only complaints that you have a good faith basis for alleging the facts in it. And I would recommend everyone go back and read Federal Rule of Civil Procedure 11, which has some of those constraints in it. It's important to keep in mind. Beyond the larger goals of the complaint, we also had a few strategic choices that we considered in putting it together, and I'll go through a few of those briefly. The first is, when do you sue? There's usually, as I'm sure you're aware, a statute of limitations involved in any claim that you bring. When we first got this case from Professor Atuahene, we didn't actually have in mind a particular time when we were filing. Once we looked a bit closer, we realized that most of the violation we were alleging occurred in 2017, and in Michigan, there's a 3-year statute of limitations for bringing 1983 claims. So that gave us basically a window of a few months to put this together before our claims would be time barred. And we wanted to make sure to set that deadline to get everything into the court to avoid that limitations bar. The second strategic choice was, where do you sue? And this is really a follow-on to Ajmel's discussion of the difficulties and strategic trade-offs between federal or state court. For the state court angle, we recognized, following on from the Morningside litigation, that if we were challenging anything to do with the underlying assessments that people had, and many of our subclasses in our litigation, we were challenging that they were overassessed to begin with. Morningside basically told us you couldn't go through state courts, you had to go through this alternative administrative body, the Michigan Tax Tribunal, in order to have those claims heard. On the other side, in federal court, as Ajmel mentioned, the Tax Injunction Act is a real bar to bringing challenges to state tax schemes. And so we knew we had a pretty narrow window that we would have to fit in through federal court if we were going to file there. And in the end, we decided to go with federal court, both because I think Morningside scared us off of state court in lots of ways, and we thought that the particular facts of our case would allow us to avoid the TIA, the Tax Injunction Act. We were really only challenging whether we were asking the state and the city to follow precisely the procedures that they had in place that the law should have had them follow. And we weren't asking them to change or challenge that system. So we thought we could avoid the TIA at all. And we also thought that Morningside was a pretty strong precedent to show the federal court that we couldn't bring at least certain parts of our claims in state court anyway, and that it would be pretty futile to do that. The third consideration strategically was, who do you sue? And as you saw from our complaint, we ended up suing a mishmash of state, county, and local entities. And we just carefully considered each one for who would be the best to bring as a defendant in this case. Obviously, the city oversaw the property tax notices and that administration. We ended up suing the city itself. We also wanted to sue the entities within it, the Office of Chief Financial Officer and the Office of the Assessor, that were responsible for sending these property tax assessment notices. And we decided to sue some individuals who were, we thought, particularly accountable, including the city assessor himself, and also the mayor, who's the elected leader of the city and oversees this whole administration. We also knew from Professor Atuahene that the State Tax Commission had control over the Detroit Assessment Office in 2017 when we were bringing this lawsuit. So we wanted to bring them into it as well, but you always have to be wary about immunity doctrines, and you can't usually sue a state directly or a body of a state unless that state has waived what's called sovereign immunity. But we could sue under what's called the ex parte Young doctrine, individuals who work in state bodies in their official capacity. So we sued the commissioner of the State Tax Commission and also their executive director to try to bring in anyone who could be accountable for this, but who would not be able to rely on immunity doctrines to kick our lawsuit out. And finally, while our suit really focused on the due process issues, we also knew that the foreclosure and delinquency fees crisis that had faced people in Detroit for years was really a function of Wayne County. And Wayne County was the entity that was benefiting financially from those payments and from foreclosure sales. So we wanted to bring in Wayne County. We also knew from Professor Atuahene that the activists who'd been on the ground working on this long before we as litigators were on the scene wanted to hold Wayne County accountable for part of this. So we ended up bringing Wayne County in, but under an unjust enrichment claim instead of due process. And last, I just want to briefly talk about the process of finding and working with plaintiffs. And again, as litigators from Chicago who were brought in to bring this case, we had really no connection to individuals who were on the ground in Detroit who might have been affected by this or who would be interested in being plaintiffs. And that was why working with Professor Atuahene and her students and the Coalition for Property Tax Justice was an essential part of bringing this case and would have been impossible without it. So through them and the property tax appeal clinic that they ran, we were able to figure out who would be interested in being part of this lawsuit and who might fit into the various subclasses and classes that we were hoping to bring, because we always viewed this as a class action that we wanted to bring. Those folks were able to be sent up to us as leads. We could interview them and see that they were interested in being part of the lawsuit and retain them as clients. And as you read, we've got five clients who in some way fit into each of the classes that we were bringing as part of this lawsuit. So it's just worth underscoring that this is a community effort, and while we were able to play a role as litigators, it took real on the ground knowledge and know-how to make it happen. So that was the complaint process. We ended up getting it filed within the statute of limitations deadline. And I'd like now to pass it to Betsy, who will talk a bit about our next step, which is the live issue of fighting the motion to dismiss.
Yeah, so we did file within the statute of limitations by like 12 to 14 hours for sure. We had like a lot of leeway. And, a big part of what Sam just described is how we as the plaintiff's counsel and our plaintiffs are the master of the complaint. We're choosing who to sue, and we're choosing where to sue, and we're choosing what to sue for. And it feels like, especially for Rami, Sam, and I, who are often on the other side of the V in our work, we do a lot of defense side. It's exciting, and it feels great to kind of get to command what you're bringing in front of the court. The first thing out of the gate, though, then is the motion to dismiss. And after you feel like you've really put this together, the defendants here, they poke holes in it and they try to find any way. And it does sometimes feel like the plaintiff has to be right about everything, all of the law, all of the facts, everything has to be right. And the defendant has to get like one thing right to win. But that's not really true. And we really guarded against it, and we drafted the complaint from the outset anticipating this motion to dismiss. But it is a kind of a brutal or like kind of a jarring exercise to try to defend what you've put together. And so we just wanted to talk through some considerations there. The pleading standard is something we should talk about. You guys have all had Civ Pro, and you know about Iqbal, and you know about Twombly, and you know that you have to plausibly allege facts that give rise to a complaint that state a claim. And so the standard is on plaintiff's side. You're not supposed to have to prove your case from the outset, but it isn't nothing. You have to plausibly allege it. And so at base, when you get the motion to dismiss or motions to dismiss, you want to look for a way to give the judge and her clerks a clear path between what you allege in a complaint and where this case would eventually resolve. And so you want to make sure you explain to the judge that she has the power to hear the case. So if you guys have taken Fed courts, that includes jurisdiction, but it also includes venue. And it says that this is the place that this case should be brought. And then you need to make sure all of your facts and you pull them together to show the harm that was committed. And that would, for standing would be the injury in fact, but also just kind of giving the judge all of the baselines from your complaint that said these are the harms that were alleged, and these are the people that created that harm. And finally, that the plaintiffs that brought the case suffered the harm. And so that seems really straightforward, but organization in a motion to dismiss opposition is absolutely paramount. And so you have limited space, right? And you need to focus on really threshold issues. And as Sam explained, we sued 3 sets of defendants. We sued state defendants, city defendants, and county defendants. And there we sued different claims. In county it was unjust enrichment because we couldn't sue the state tax commission for damages. We sued them for an injunction. And then the city, there's the assessor, and so everybody, each of those defendants had different arguments against it. There's certain notice provisions in the Court of Claims, or there's an immunity argument that maybe doesn't apply to the mayor, but it maybe applies to the assessor. And so there were little pieces, and we got 3 motions to dismiss, and we made the strategic choice to try to respond in one brief. And that's a real consideration you have. On the one hand, all 3 of these defendants brought up the same tax injunction issue. And so it was nice to respond once, but on the other, they all brought kind of individual claims too. So we made this consideration, and you'll want to think about it. We successfully persuaded the court to give us a little bit more space in one brief, and that allowed us to take all of these piecemeal arguments and put them in the larger context of our brief. These are what we claim. These are what they allege is deficient about those claims, and here's why they're wrong. And it really allowed us to put the narrative forward. Granted, we don't have a ruling on the motion to dismiss yet, so I'm saying this with so much confidence. I think we did well, but we'll see. But we did have to then maybe not fully flesh out other arguments, right? Because some of the little ones, that would be one defendant and one claim, and it would limit the remedy for that, but it didn't touch the rest of our case. That might not take up a lot of real estate in the brief because we had to make decisions on what went in. But on whether or not we had standing to sue, whether or not the court had jurisdiction, well, that was obviously going to be front and center because that was a threshold issue. But we all clerked before, and many of you may do that too. And I think you'll know that both judges and clerks will appreciate the opportunity to streamline your arguments. And so our decision to file one omnibus opposition brief, as opposed to kind of swatting away each individual defendant, I think was well taken. And she immediately granted our motion for a little more time and a little more space so that we could do this all at once. And I think that really helped. But again, we did have to make some decisions and kind of not fully respond in a way that we could to a longer way to a short argument that didn't dispose of the case. On drafting a brief isn't that different from drafting the final paper you'll be doing in this class, to the extent you have a good writing is good writing, whether the judge or your professor is the audience. And I think everybody's got their own methods, and we're certainly not ones to tell you how to do it. But a couple things that, as a new associate drafting my first briefs, was important to know is, first, to keep that standard in mind that we talked about. I think there is a intuition that you want to win your case on the motion to dismiss, and you don't have to. And also, you haven't gotten any discovery yet, so you probably can't. And so keeping the standard in mind to say, these are the way we've pled it, this is why it states a claim, and we get to unlock the doors of discovery with this, and we get to find out more. We get to depose some of these folks and get some documents. if you have thorny issues, thorny legal issues, so for us, it was the Tax Injunction Act. It could be preemption. It could be qualified immunity. I think kind of a life hack for that is just finding your judge on Westlaw, the judge that's going to hear the motion, and find out if they've heard this issue before. If it's qualified immunity, they for sure have. But if there's any number of things that you just want to make sure that your judge, if they've already considered the merits of this in a different case, you either can rely on that, or if it did not go the way you wanted to, you will want to head that off and factually distinguish it. One kind of last little point is that we were set to do oral argument on this motion. In the Eastern District, I think there's kind of a general standing order that most dispositive motions have oral argument. Other courts are totally different. When I was a district court clerk, I think we had oral argument on like one motion to dismiss, so it's not all the time. But when you do, it's a different beast than the motion itself, right? And you guys, I don't know if you've done moot court, but it's the same idea, but at the trial court level, where you don't really know what your judge is gonna have. They might not let you get through the intro before they start peppering questions. They might listen to your whole spiel and not have any questions. So I think prepping for that and knowing that the way you prep, the way you like outline for a course is probably helpful for outlining for oral argument, which is to say all of the really important cases, you should know, what they are and what they held and how they're different or the same. And kind of just maybe prep when Sam and I were prepping for oral argument that eventually got canceled from COVID, Rami was gonna kind of mock argument us and stuff. Wherever you are, if you're able to do it, I just think it's a preparation for oral argument is super different from the drafting the opposition of the motion to dismiss, although they're obviously kind of similar issues. But those are all the tips that we really have for the motion practice there.
The only thing I would add oh, sorry, Bernadette, go ahead. I had maybe just 2 more minutes, and then I'd love to hear any questions that the students might have. I would just add one comment on sort of the oral argument piece, which unfortunately we didn't get to do, as Betsy said, but in my experience, similar to how writing the brief can be an exercise in prioritizing, sort of winnowing, cutting off the fat of arguments to really present them as clearly as possible. Oral argument to me is sort of that process on steroids in some ways, because you have so little time. You in federal court, you might only have 5 minutes. You might only have 10 minutes if you're lucky to sort of give your presentation. And as Betsy said, you're going to get questions most likely during that time. You might not even get 15 seconds of argument off before you start being peppered. And so for me, when I'm preparing for an argument, you want to know everything. You want to be the master of all the facts and the law, and have your big binder that has all that information. But you also want to go through sort of a successive process of taking your big outline and then making it half as big, and then make it half as long again, and get to where you really have sort of a 1-page list of key bullet points, and you know them by heart, and you know what the first 2 sentences are that you're going to say to the judge without reading them, because you really want to convey tightly to the judge quickly what your position is. And we did a little bit of that in our brief with sort of the 1-page introduction in our opposition, but for argument, what we would have done is really go in there with a very tight summation of sort of what are the 3 key points we want the judge, really the clerks as well, to walk away from, thinking about our argument and our position from there. So that's what I wanted to add on argument.